good evening or good morning, depending on where you're tuning in today, but thank you for coming. Welcome to the latest ICRWDA webinar, trying to bring you elite level training at no cost to you. And just a couple quick thank yous. Thank you to Protective Force International for helping sponsor this particular webinar. So thank you. Also want to thank AWPDA for letting us use your Zoom account. Thank you for that. And of course, John Peters. We're all here today to talk with John Peters, who, as you probably already know from the brochure that we've sent out, is not only an attorney, but he specializes in canine case law and canine lawsuits and that kind of stuff. He's definitely the subject matter expert on this, and we're very honored to have him here today. So briefly, we're going to start. I'm going to turn it over to John here in just a second. We're going to start with the written questions that were sent in with the registrants, and then if we have time after the written questions are taken care of, we might be able to take a couple questions from those of you tuning in today live. So with that, let me turn over the screen to John.
Okay. Hello, everybody out there. I want to thank you all for taking the time to send along your questions. I'm going to try to answer as many as I can. For those that I don't have answers to, I will promise to follow up with you because I've got your contact information and do my best to get you those answers. If not in our short time today, then certainly down the road. So I've been looking through a lot of your questions, and generally where canine is involved, these are all Fourth Amendment issues for the most part, where you're public law enforcement. That would be either the use of force with the dog or search and seizure issues, which are about probably 90% of what you're doing out there. Now, there's a dividing line where the law is concerned between private security and public law enforcement. Private security is not subject to Fourth Amendment analysis for things like search and seizure or use of force. You just fall under the general civil liability laws of your particular states or jurisdictions. So, for example, if you use your dog in a private facility to conduct a search for narcotics, or if you use it to conduct a search for explosives, nobody can challenge that on Fourth Amendment grounds. They can only challenge that as to whether you were or were not operating reasonably, as the civil law would define it. In other words, were you negligent? So one of the questions that comes up often for me, and maybe this helps frame it, is, are there situations where you can use your dog, and I get this from law enforcement as well, to conduct a sniff of a person, either for explosives or for narcotics? And the answer to that is yes, there are. If you operate within a private facility, as I said, you have the right, the facility has the right to define the rules of order of that facility, and that would include how security is carried out. My recommendation in those situations where you may be using your canine in a detection capacity, either for narcotics or explosives, is to make patrons known of that procedure. That's important because somebody could later claim, well, I had no idea and I wouldn't have gone into the place if I knew that they were going to do that and they trapped me, and so on and so forth. If you have a policy, and many places do, that announce in advance that it is a condition of entering the facility to subject yourself to these procedures, then you're fine because they've been put on notice, they understand, and they've agreed to move forward. Now, same applies in the public realm if you're public law enforcement. You know, I'll give you a few examples where those Fourth Amendment rights get effectively waived by private citizens as a condition of entering a particular facility, all your correctional institutions, people are put on notice that they're subject to search before they enter, right? They have a choice. They can enter and they cannot enter. If they choose to enter, then they're waiving that right and they're subjecting themselves to that procedure. In the private sector, sporting facilities, sometimes it's printed right on the ticket that gives you admission to the event that you will be subject to these procedures as a condition of entering. And once again, the person has the choice. They don't have to enter and be subject to that, but if they do, they place themselves in that position to be subject to search or some form of detection. So that's the first line I guess we want to separate, is between those of you who work in private security and those who work in public law enforcement. Any public law enforcement employee, your searches and seizures are all analyzed under the Fourth Amendment for reasonableness, but that's not true with respect to private security. There was another point I wanted to make there. Oh, if you are in private security, but you are acting in concert with public law enforcement, maybe in a particular assignment or particular event or whatever, but you're there as an extension of public law enforcement, then your searches and seizures can be subjected to Fourth Amendment scrutiny. It all depends on whether the courts feel that the relationship is close enough that you're effectively an extension of the public law enforcement agency. But as long as you're purely private and you're operating in that fashion, you're not subject to the same Fourth Amendment restrictions that public law enforcement is. Okay. So with that, we got a lot of good questions, and I'm gonna try to get to most of them or all of them. One question I got is, what is the importance of certifying canines with state organizations and then some or national organizations for courtroom testimony and civil liability? So when it comes to certifications, I will tell you this. The courts are more focused on the quality of the certification than the size of the organization that grants it or the fame of the organization, let's say. So you could have a local training facility that has stricter certification standards than a national organization. And that's really what the courts are going to look to. They look behind the actual certification, that piece of paper, to ask, what did you have to do to get this? And if the stricter requirements are with a local versus a national organization, then you're better off with the local organization. Yes, the national organizations have some, what I'll call pre-recognition or acceptance in the courts, but that's not determinative. If you go through the case law, they really want to know what was involved in obtaining the certification to determine whether you and your dog are a reliable team for the particular issue that's before the court. What about unimprinting marijuana dogs for states that have recreational use laws? Well, this is an issue that's probably longer than I'm going to talk about today, but I'm not a trainer, so I don't know how valid unimprinting a dog is once he's been imprinted on marijuana odor. I've heard both schools of thoughts from very good trainers. Some say that it absolutely can be done. Some say that it's not reliable. So I'm not the guy to answer that part of it. In terms of whether it's needed at all, remember this, that my state, I'm in the state of Michigan, and the state of Michigan is a good example. We have both medical use marijuana and personal use. No court in the state of Michigan has ever ruled that an alert by a marijuana detection canine no longer serves as probable cause to search because marijuana can be legal. And remember this, even in states where it's legal, the general rule is that it's illegal. So stay with me on this. Personal use and medical marijuana are two areas where they are exceptions to the general law that possession and use of the substance is illegal. They're very highly regulated in every state. Who can grow it, where it can be grown, how it has to be stored, how it can be transported, who can sell it, where it can be used, and so on. As long as you're within those restrictions, you have no problem. You're within the law. But the minute you're outside of those, you're back into the general area where the law makes it illegal to possess and use the substance. And really, if you think about it, it's no different than any other state regulated item. Take prescription medication. It can be legal, right? You have a valid prescription and what you possess is what was authorized to be issued to you. It's legal. You've got 150 Vicodin pills in a brown paper lunch bag and no prescription. That's a felony. Okay, so it's not really the substance that defines the legality of it. Firearm is another example, right? There's circumstances where you can possess a firearm legally and there's circumstances where you can't. And if you have a permit to carry one and your gun is not stolen and it's registered and all the T's are crossed and the I's dotted, you're fine. On the other hand, if you have a gun in a car and you don't have a permit to carry that weapon, that's a felony. It's the same item. It's a gun in both cases. One instance it's legal, another one it's not. So back to this general issue about whether we need to unimprint marijuana imprinted canines or whether we need to stop training canines to detect marijuana. That's really a policy decision of each agency to make. But there is no law that says that those dogs cannot be in use or that an alert by those dogs cannot, at a minimum, contribute to a probable cause finding. Most states, it is outright probable cause. California, Colorado tend to say that by itself, if you don't have anything more, the alert is not probable cause if the dog's imprinted on marijuana. I think it's a distortion of the law, frankly, because your dog is usually imprinted on several substances and he can't tell you what he's alerting to. So to assume that he's only alerting to marijuana and then only to a legal amount of marijuana, it's kind of a stretch. And that's really not how probable cause operates. So for your question about whether the dog can be unimprinted, number one, I'm not sure it's necessary, but number two, if your agency decides they want to move away from that, you'll have to talk to a qualified trainer to find out how effective that process would be. All right, let's look here. All right, I've got a question here that's not quite clear to me, but I think I know where to go with it. It says, are you seeing a trend in courts concerning how a narcotics dog and handler appear during the exterior search portion, touching cars, dog indication, etc.? So let's talk about this topic generally. The courts have held, and it's still the law, that as long as you are conducting a free air sniff of the exterior of a vehicle that's in a public place, you don't need the consent of the owner and you don't need a warrant to do it. That is not considered a search under the Fourth Amendment. However, there are limitations. Number one, they don't want the dog's nose touching the vehicle. What they're giving you the freedom to investigate is the air surrounding that vehicle, because in the court's view, there is no expectation of privacy in the air around your vehicle on a public highway. If your dog alerts, that's probable cause to search the vehicle without a warrant, and that search can include your dog. But that's permission to search the vehicle, okay? At this point, it's not permission to search the occupants. Now that law gets very complex. So you kind of got to know what state you're in. And if any of you want to follow up with me down the road regarding your particular state, that's fine. But I'll tell you the general rule is that the courts want something more than an exterior alert to the vehicle, a search of the vehicle that turns up nothing, and in order for you to search the occupants without a warrant. They want something more to tie that occupant that you want to search to the dog's alert. That's the general rule. However, there are exceptions around this country. The 10th Circuit, if any of you work in the 10th Circuit, that Federal Circuit rule under a case called Anchando says that the canine's alert to the exterior of the vehicle is probable cause to arrest and search anybody who is in the vehicle. So that's the strongest rule. That's the one end of the spectrum. But then there are the majority of states that say you have to have something more. So what's the something more? Well, it can be a number of things. It could be that the dog showed particular interest, for example, in one of the seats in the vehicle during the interior search. Some courts have held that, in addition to the exterior alert, can be probable cause sufficient for you to search the occupant who was in that seat. Not everybody, the occupant who was in that seat. Other items can be prior information or information provided to you on the scene by another occupant of the vehicle about one of the other occupants of the vehicle. Anything that ties in and focuses the suspicion towards one particular individual or more than one individual. I will tell you that there's a very interesting, I don't know if I'll call it a trend yet because it's only 3 states, but Illinois, Florida, and Indiana have all had rulings where the court suggested that the handler could have used the dog to conduct a free air sniff of the occupants. So I think what they're talking about is kind of a neutral pass by the occupants if they're outside of the vehicle, and if the dog shows really intense interest towards one of the occupants, they said, well, we'll take that as the additional piece of information to justify the search of that person. You have to be careful with that for obvious reasons. You don't want your dog inadvertently biting somebody in that process. But that's the general rule. Exterior sniff that leads to an alert is probable cause to conduct a warrantless search of the vehicle. If that warrantless search of the vehicle does not turn up any contraband, you need something more to search the vehicle occupants. Now I'll make it really confusing for you. Some states say it's enough to search the driver and owner of the vehicle, but not the passengers. Why? Because the driver and owner are presumed to have a greater level of knowledge and responsibility for the vehicle and what is in the vehicle and taking place in the vehicle. Not every state does, some states do. Second line of separation is whether the individuals that you want to search were in the vehicle when the dog alerted, or whether they were outside the vehicle when the dog alerted. Some states say as long as they were in the vehicle when the dog alerted, they're subject to search as well. But remember, the general rule is as I described it. So the courts want something more that directs your suspicion or probable cause toward that individual. I had an interesting situation come up in the state of Idaho. Back in February, I was teaching in Idaho, and shortly before I went to Idaho, their state Supreme Court made a ruling regarding what happens if your dog enters the vehicle through, let's say, an open window during the exterior sniff. And a lot of the handlers in Idaho were quite concerned because the court seemed to be saying anything that comes as a result of that is no good because your dog entered the vehicle and you didn't have a warrant to enter it. But really, if you read the decisions, it falls in line with the general rule. All the court was saying in both cases is for your dog to have the right to enter the vehicle, you have to be able to articulate why you know your dog's change of behavior indicates the recognition of odor coming from the vehicle. So what I'm counseling all of you who are public law enforcement handlers in that situation, it's really quite a simple approach. And that is, if you have to testify, you have to be able to describe the change in your dog's behavior that you recognize as an indication that he's in odor. Once you have that, the courts will accept that as probable cause, just as if the dog alerted otherwise. So whatever that behavior is that tells you that your dog is in odor, that gives the probable cause. And then if your dog enters the vehicle on his own, the courts are not going to penalize you because you already had probable cause, and therefore you would have had the right to enter it anyway. Where the handlers got in trouble out west, where they were unable to articulate that. And the court said, well, there's nothing in your testimony that tells me that you had established probable cause before the dog jumped into the car. And you cannot enter a vehicle, nor can your dog, unless probable cause is established first. So when the court's going to ask you, how do you know that that change of behavior indicates that your dog is in odor? How are you going to explain it? Well, you're going to have to relate it back to your training. And in your training, you want to be able to demonstrate that the same change of behavior you saw on the street is the change of behavior that you described by the same term in training, and that you've proved that through training, meaning that when there's that change of behavior, narcotics are found, okay, in training. So in training, we control those outcomes because we know where the hides are, we know where they're not. So if your dog is alerting, there should be physical contraband that you can produce. That's the evidence coming from your training records that whenever you see that change of behavior in your dog, it leads to a discovery of narcotics. Now, you're not always going to discover them on the street. It may just be the odor, but that's all the court cares about, is whether the dog is indicating that he's in odor before he enters the vehicle. All right. So just to sum up that point, make sure that you use the same terminology to describe that change of behavior in training and on the street. Don't change the description. Don't give it one name in training and a different name on the street. And number two, make sure that it's the same change of behavior in both cases, and you'll be fine. Okay, hang on. Let's see if I've got some private security questions here. Oh, well, here's an interesting one. It says, is there any known civil case law on properly marking canine vehicles, meaning having a canine in an unmarked vehicle? So I assume you mean for civil liability purposes, in case something happens, somebody enters the vehicle. I don't know of any real cases on that. So, you know, do you need to warn people generally? Do you need to have a decal that says, you know, canines stay back? And if you don't have it and somebody gets bit, is that going to lead to civil liability? It could. On the other hand, why are they entering your vehicle in the first place? I don't know. They have to get over that hurdle first. So, you know, you have to be careful, and canine handlers have to be careful too, making sure that your vehicles are secured when you're not with them, that your crates are secured. I do know of cases where out of marked vehicles where canines were not secured and they made their way out and bit an innocent person. And, you know, that definitely is going to lead to a lawsuit that you want to avoid. So for unmarked cars, I don't think there's any requirement, but it just puts a higher responsibility on you to make sure that that vehicle is secured from unauthorized entry. I mean, if somebody breaks into the vehicle, that's a different story. That's their problem. But if it's some inadvertent entry into a vehicle, then you want to make sure that the dog is secured as well. Because even if they get in the vehicle, as long as the dog is crated and secured well, there shouldn't be a negative outcome. So just got to be careful with your dogs and your vehicles. Let's see. Okay, here's a guy from New Jersey just asked me what we just talked about. If canine alerts on the vehicle, can I search the occupants or the person after the canine indication? So that's what we just talked about, but I'm going to call him out here. Officer Palma, if you want to reach out to me, I will try to pull you up some specific New Jersey case law on that. And my contact information's on the handout. You can email me, text me, whatever you want. All right. I see I have a cadaver dog handler out there. They asked if it's okay to join. Everybody's welcome that works a dog. I don't know if you have a specific question, but I don't see one. We're glad to have you though. All right, here's one. Person who is trained to search for impaired people, lost children, dementia patients, autistic children, and it's a remote area. Let's see. What are a few of the most common things to be watchful of in an active search? Okay, I'm glad you asked this question. I had a call from a handler in a North Carolina department who needed some guidance because their patrol dog was used to go and search an elderly woman who became lost in a remote kind of undeveloped area. The dog located the woman and he was on top of sort of like a pile of branches and he fell through and he landed on top of her and bit her. And his commanding officer said, we're never doing that again. And he wanted to know what should they do in those situations if they're asked to go and search. So here's my suggestion. If you're in that role where you're searching for lost people, you obviously don't want your dog to bite some innocent lost person or a child. You're just trying to locate them. A muzzle, if your dog is trained to track in a muzzle, that's an excellent precaution to prevent that outcome. But not every dog tracks well with a muzzle on. Depends on how they're trained. What you want to show, I think, is that you went through a list of considerations before you set out in search of this person, how long they had been missing, what their age or physical or mental condition was, how many hours of daylight remained, or how long it would be until daylight came. For example, if you're out in the early morning hours, it's dark. When will daylight next be available? What other methods have been used and what were the results? And in the end, after you go through this analysis, weather conditions, hazards, terrain, you're going to come down to a decision that it's still safer for you to go and look for this person with the dog, or it's not. But it won't come across as some impulsive decision or not well reasoned. And as long as you've thought it out and weighed the alternatives and put some thought process into it, the courts are not going to penalize you, even if inadvertently somebody gets hurt in the end. As long as you can demonstrate, it would be more dangerous for you to not go in search of them. Okay. All right, let's see what else we got here. Somebody asked, are more canines being trained to detect fentanyl? And if so, what impact is that making in the legal field? I got to be honest with you, I don't know. I know that there's a lot of dangers associated with detection dogs working in or around fentanyl. And a lot of dogs have been lost, so I don't say a lot, but too many. It's a very volatile, kind of dangerous substance. You don't know what kind of response that's going to have with a dog. At the same time, like any other narcotic that's contraband, you know, the government is interested in detecting it and getting rid of it. So I know dogs are being trained in it. In terms of how that impacts the law, maybe I think your question might be, well, fentanyl can be legally prescribed, and it can. So is there a danger that your dog is trained to detect it? Sort of falls back on our marijuana analysis, right? It's not always going to be legal. So the question becomes, if there's a chance that the dog, let's broaden this. If there's a chance that the dog could be detecting a legal substance, does that mean that the dog's alert can no longer be probable cause? My answer to you is no, because that's not how probable cause functions. Probable cause is whether there's a probability or a substantial chance of criminal activity. So sometimes even innocent behavior can give rise to probable cause. You can have probable cause, do your investigation, and find out there really was nothing wrong. That doesn't mean you didn't have probable cause, because probable cause isn't determined after the fact, it's determined up front. So if you have a dog that's imprinted, let's say on 4 different odors, and the dog could be alerting to a substance that has some components of the illegal narcotic, but it's legal, does that mean now that you no longer have probable cause? No, and I'm not aware of any court that's ever said that, other than the McKnight court in Colorado. And the McKnight court in Colorado is actually kind of out there just by itself, and they kind of know that too. But the rest of the states and the federal circuits, US Supreme Court, they've all recognized not only that the dog could alert to a legal substance, but that the dog could just be mistaken. They're not perfect, they're just dogs. And the courts have never based the reliability standard on it being 100% accurate. They never have. So I don't see where it's any different, whether it's fentanyl, marijuana, or any other substance, because let's look at that, okay? If we take the Colorado decision, the ruling of the Colorado Supreme Court was that the handler has to be able to establish that the dog could only be alerting to illegal contraband or an illegal amount of marijuana. Well, how are you going to establish that? The dog doesn't tell you what he's alerting to. But if that was the standard, then think about an explosive detection dog, for those of you that work in EOD. Couldn't your dog be alerting to a legal weapon, or legally owned ammunition, or legally owned black powder, or legally owned fireworks? Of course. Does that mean now that their alert has no value and it can't be probable cause? No, no court's ever said that. So I don't know if that's where you were going with the fentanyl question, but I hope I covered that.
Hey, John, this is Ryan with ICRWDA.
Yeah.
If I can jump in, I've gotten a couple questions directly to my phone here.
Sure.
So specific to private security, this is one of the questions. Apprehension or bite dogs as far as use of force. I know there's lots of states that have citizen arrest statutes. Here in Nevada specifically, private security is allowed to make arrests on both misdemeanors and felonies with some caveats. But one of the questions is, for security handlers that have a bite dog, what are the legal ramifications for using that dog on company property, as in like a casino, and on the casino property? And does that differ for other private security companies that are on third-party property, like an apartment building or whatever it is that they've been contracted to protect?
Yeah, so it goes back to something, Ryan, you and I were talking about when we were setting this up, and that is whether your private security group have law enforcement powers or whether they don't. Some do and some don't. As to those that do, you're going to be kind of held to the Fourth Amendment standards of public law enforcement, because that's sort of the hallmark of a state actor, is that you have arrest powers. Okay. If you don't arrest, then obviously this probably isn't going to come up, right? So you're going to call in law enforcement to handle that end of it. For a bite dog in private security working on private property, you're not subject to an analysis of whether that was excessive force under the Fourth Amendment. You would be subjected, to an analysis of whether the behavior was reasonable. So what does that mean, right? Reasonable. Well, reasonable in the civil law, this is where the negligence concept comes in. And the way it would be measured is they're going to bring in industry experts who say, yeah, no, he shouldn't have done this, or the dog wasn't properly trained, or the handler shouldn't have deployed the dog in this, or whatever. But it's all going to be measured by civil liability standards and not under any laws that govern Fourth Amendment. If you're private security on somebody else's property, and let's say you're pursuing somebody from your property to other private property, and the dog is used to physically apprehend an individual, if you have arrest powers, then you're going to be analyzed under a Fourth Amendment standard.
And arrest powers being different from citizens' arrest powers,
yes,
as opposed to law enforcement.
Yes, absolutely. Yeah.
Excellent. Thank you.
So that's the dividing line again. Private security, no, you're not going to fall under all these, like 42 USC 1983, the federal statute. You're not going to face all this Fourth Amendment scrutiny, but you will be judged by a negligence standard or reasonableness standard. And to some extent, they kind of dovetail. It's just that there are different avenues where a public law enforcement is involved than private security. And private security gets to define their own rules. I mean, for premises, it's their premises and they can define the rules however they want, but you're still going to be subject to potential civil liability. Anybody can file a lawsuit and say you were unreasonable in your conduct, you were negligent, or you were grossly negligent, but it's a different standard than a Fourth Amendment test.
Excellent. Thank you so much for clarifying that.
Yep.
If you've got more questions on your written thing, go right ahead, John. If not,
okay. I thought you had a few more, but I'll go back to it.
I do have one more for you, that if
ahead.
I could. And I think you've somewhat already touched on it, but when it comes to private drug detection, dogs for private security, and again, we already kind of touched on that Fourth Amendment doesn't apply for private security. But kind of coming back to the same thing we briefly talked about as far as citizen arrest, if you're in a state that allows such things, and that's how normally the private security is affecting arrests.
Right.
A drug dog finding narcotics, then obviously no Fourth Amendment search issue. The private security officer goes in, finds narcotics to the best of his training and experience. It looks like it. They want to go ahead and make an arrest. Is that something that you see pitfalls in?
It's just it's a funny line, but let's say you arrested an individual at a casino, okay, and they had possession of narcotics, and you're detaining them. Well, you can detain them. There's not a problem with that. And you can detain them as private security, but then you have to hand them over to law enforcement, essentially. You bring law enforcement into it, right? And the difference is where law enforcement has you acting as their agent to try to, they're surveilling somebody and they want you to set up the detection and the discovery of the contraband. Okay, now the court's going to look at that as, well, you're just an arm of law enforcement. So it's that distinction. If you're acting in a truly private capacity and then you detain somebody. No, private security generally has the right to detain people. I mean, so on the premises, but you have to act and you have to bring in law enforcement if you're going to pursue it. You know, otherwise, I guess you'd let them go and there's no harm, no foul. But let's say somebody was detained and they say he shouldn't have detained me, he had no right to detain me. What can that lead to? Again, it's going to be an issue of civil liability, but Fourth Amendment considerations don't come into it unless you have that kind of what I call that veil of public law enforcement to your operation.
Excellent. Thank you for clarifying that as well. And I'll
Sure.
let you get back to whatever questions you want to answer on your list. And then we've gotten a couple in the chat room here as well. So I know
Yeah.
we're getting close to the end here. So I'll let you choose what you'd like to answer.
Sure, let me look. Oh, here we go. Somebody from Wayne County. I don't know if it's the Wayne County near me or another Wayne County. There's a lot of Wayne counties, but it was a question that we talked about earlier about your dog entering the vehicle during an exterior sniff. I'm glad this question, I found this because there's a couple other points I wanted to clean up about that. The test for the courts in almost every jurisdiction is, number one, was the opening on the vehicle, whether it was a window, door left open, whatever the point of entry was that the dog entered through, the courts want to know, did the occupant of the vehicle leave it open, or did you direct them to leave it open or open it, or did you open it? If you directed them to open it or you opened it, then it's going to work against you. If not, and they just left it open, then that's their problem. The second element is whether the dog is entering that through that opening instinctively, or whether you're directing the dog through that opening. If you're directing the dog through the opening, the courts are probably going to disallow it. So they're saying, fine, as long as the dog is working as trained, he's following this, he's going to the strongest source of odor, and he picks up on it coming through the window of the car, and he goes through the window of the car. Okay. And back to our Idaho example, as long as you can articulate that he was in odor before he entered, then you're okay. So it's those two elements. Did the dog enter instinctively, and was the opening left open by the occupant of the vehicle? Let's look here. Oh, here's one from officer in Georgia. He's talking about changes in the law in Georgia and when can free air sniffs be conducted. The decision he's talking about says that the officer who stopped the vehicle has to be conducting something to do with normal traffic stop, and the stop cannot be extended. Yeah, that's the Rodriguez rule out of the U.S. Supreme Court. So for canine handlers, the rule is, in order to conduct the canine sniff, it has to be conducted within the window of the time that it should take, whether you were the officer initiating the stop or there's another officer, whatever time it should normally take to process the motorist for the purpose that you stop them for. So simply, you stop them for a speeding violation, they have a valid driver's license, insurance, registration. That's a pretty short stop typically. And what they're saying is you can't interrupt that process to take a dog around the car. And if in doing so, you delay the process or you interrupt the process, then whatever occurs after that is no good if you find something. So there's kind of two different scenarios to think about. One is a regular patrol unit initiates the traffic stop and the canine handler arrives in backup. If you get there relatively quickly and You can get your dog around the car before the traffic stop is concluded. You don't need consent. You don't need reasonable suspicion of criminal activity. You don't need a warrant. You don't need probable cause. You can simply take your dog around the vehicle as long as it's within the time of the traffic stop. Now, let's take a different situation. You're the canine handler, you initiate the stop, and you want to take your dog around the vehicle. Well, you're kind of hamstrung. How are you going to do that without interrupting the processing of the traffic stop? Kind of hard to do. Courts have held that if a backup unit arrives in a relatively prompt manner and they take over the processing of the traffic stop, then you can take your dog around the car. In other words, you don't have to be the one to complete the processing of the traffic stop. They just don't want it delayed or interrupted for the purpose of doing the canine stop. I hope that was helpful to my handler that asked from Monroe Police Department. Let's see, what else do we have here?
John, just quickly touching on that particular ruling and what you're talking about as far as extending the stop, if you're the canine officer that did the stop, would it be okay if you're conducting extra computer searches or asking your dispatch center to go ahead and check like interdiction stuff? A lot of times we would do, sorry, that's my retired dog barking. But extending the stop to do like searches through Epic or El Paso Intelligence Center, having your dispatcher do that. Those are usually at least a 6-minute search if you're doing them consistently on your interdiction stops. Would that qualify under Rodriguez?
Yeah, as long as it's something that's serves a purpose and is part of the normal procedure of a traffic stop. So if they start a really diligent defense attorney starts digging in and he sees that you don't do that normally on a stop, that's a big red flag. Like, okay, you were just doing that to buy time to be able to take the dog around the car.
God, because this looks like a POS or someone that may have dope. You're doing a different set of requirements or searches to extend the stop for that guy as opposed to doing it on every stop or every interdiction stop. Does that make?
Yeah, they want to see what you customarily do on a traffic stop, because really what they're saying is, look, the canine sniff's not part of a traffic stop. That's a criminal investigative method. And it has nothing to do with a traffic stop. So you stop him for a traffic stop. That's what you have to devote your time to. Now, until and unless you develop reasonable suspicion of criminal activity. If you do, now you have the right to detain the motorist and to conduct that canine sniff. So what's reasonable suspicion of criminal activity? If you think about it on a ladder, it's the middle step. It's not, the top is probable cause and the bottom is a hunch. It falls between a hunch and probable cause. So it's like a hunch that's supported by objective facts that indicate the potential of criminal activity. That's reasonable suspicion of criminal activity. You can support it with reference to specific facts that led you to believe that criminal conduct was afoot. Once you develop that, now we're out of the traffic stop rule and we're into a different area. Now you can detain them longer and take the dog around the car. But
Gotcha.
Until you get reasonable suspicion, and unless you have it, you're bound by the window of the traffic stop. But here's another qualifier. Every traffic stop can be quite different. What if, for example, there's a case where the officer initiating the stop got a rental agreement and the motorist wasn't listed on the rental agreement, or the rental agreement had expired 6 months before. So now the officer's got to go through and find out if this individual even has authority to be in possession of the vehicle. So he may have to call the rental agency or the person listed on the agreement or whatever. So the courts, depending on the complexity of the facts you run into on the stop, they're going to allow you enough time. It's not like they're telling you, well, you have 5 minutes no matter what comes up. That window can expand. It has to be that you're devoting your time to addressing those issues.
Excellent. And in that example that you just gave about the rental agreement, if you're the canine officer that made that stop, you're doing that investigation, your cover officer arrives, you can now hand that portion of the investigation to your cover officer while
Yes.
you go run your dog.
Yeah, absolutely. In
Excellent.
fact, there's 2 cases out of Ohio, and they go by the same name. It's kind of ironic. One in which the police won, and one in which they lost on this issue. And the one in which they lost, the court said, well, yeah, you called for a canine unit and backup, but the problem was you went and sat in your car for 8 minutes and you didn't do anything. You weren't busy working on the traffic stop. You were just waiting.
Gotcha. That's where that El Paso or Epic checks and all of that stuff, as long as you're actively doing something.
Right. And then the second case by the same name, they said just the opposite. They said, no, when the canine team arrived, this guy was still working on the traffic stop. And I'm sorry, it was the other way around. When the backup unit arrived, the canine officer had already remained busy working on the traffic stop, and it had not been interrupted by the time he passed it over to the backup officer. So that's all they're really looking for. They just want to see that you're busy with the traffic stop. That's all.
Excellent. I've been out of the game for a little bit, but I get tons of questions on Rodriguez, and you've just clarified all of them. So thank you. Forgive me for interrupting. I know we're just got a few minutes left, so you go ahead and hit what other questions you want, and then we do have some in the chat if you are out of questions on the paper.
Yeah, I think I'm good on the paper. Let's take what you've got in the chat. And you know, we run over a little bit by an hour. I'm okay. Don't worry about it.
Excellent. Well, truly, thank you for the extra time. As far as questions in the chat, and for those of you that are still on, if you have a particular question, go ahead and put it in the chat and I will read it to John. So the first one is from Karen Carer, and she says, to what extent is the identified instructor liable for a student's application of search skills or tactics that are taught in a seminar?
There are very few cases where instructors get dragged into them as defendants, but I always tell master trainers to be very careful, because I call them the gatekeepers. And by that, I mean this. You know, when they elect to pass a handler in a team on a particular discipline, whatever it is, criminal apprehension or narcotics detection or search, you know, it's their word. They're verifying that based on their professional experience, this team is qualified to go out on the street and do that. If in fact they're not, and they give them a pass because they don't want to create a bad feeling, you know, number one, they're not doing the public any favors. Number two, they're not doing the handler any favors, because the handler's going to get into trouble. Number three, it's going to reflect poorly on the organization and the quality of their certifications. So that master trainer is a really important component in this process, and they have to, in my view, hold tight to these standards. We have to have good standards, and standards don't move. You know, standards are like they're like a steel bar, like rerod that doesn't move. You know, so what we cannot be doing in this profession is lowering the bar to where the handler can reach it. We need to train the handlers better so that they can reach the bar. So in response to this question, is the instructor possibly liable? Potentially they could be if they passed a team that they knew was incompetent. But honestly, I have never really seen a case where a trainer got sued. So.
Excellent. And none of us want to be the first.
No, absolutely. Well, and forget about whether you're going to be sued. Just the fact that, you know, it's the bad name associated with it, right? Like, do you really want that? I mean,
absolutely. For the entire industry, nobody wants to, whether you're law enforcement, private security, or just canine in general, nobody wants to be the one bringing that bar down or giving us a black eye, for sure.
Exactly.
Couldn't agree more. Another question for you is, can private security legally perform a search in the community under the request of a police officer?
Well, that goes back to our prior discussion. At that point, you're going to be linked to law enforcement. And you still, just because they're asking you to do it doesn't mean you have the authority to do it. You know, your police powers are established up front. They're not established in the field. So you either have them or you don't have them, right? And I don't know why a law enforcement officer would be asking private security to conduct a search of a person in the field. I don't know. That's a little confusing to me.
Agreed. And I guess I would look at it as you're acting now as the agent of law enforcement, but
Right.
as a private security, you have the right to say no. You don't have to do what the officer asks you to do.
Exactly.
Would be my take, but I'm
right. And
certainly
you know what,
not a lawyer.
Ryan, yeah, let me spin off of that for a second, because I don't
Sure.
know how many of you out there do school sweeps, lockers and such, but I get this question sometimes, like, my dog alerts. Now the school superintendent or the principal wants me to search the kid's locker. And I always tell them, no, don't. Just turn it over to, you notify them that the dog alerted to this locker and you let the administration handle it. There's no need to get involved in that. But a lot of times they do want law enforcement involved in it. So
Copy. Forgive me, I just got the second half of this question from that person who said, it sounds like he's a bomb dog handler that's a private dog, and law enforcement is asking them because there's no law enforcement bomb dogs in the area. So they're asking him to do the search with his bomb dog. That makes more sense to me.
Okay, so they're asking, are we talking about a search or a sniff?
A sniff.
Okay, yeah, that's big. That's a big difference. So
agreed. The second part came in the direct message there.
Okay.
So excellent. We've pretty much already touched on that, it sounds like.
Mm-hmm.
Perfect. Let's see. The next question is, can a private handler be under any civil liability if they conduct an open air sniff of a vehicle entering their property despite the individual refusing or requesting the dog not be used?
So I'm trying to think of this scenario. So let's say this is the private parking lot of a casino or some type of private
or
facility.
Apartment building. Yeah.
Okay. And walk me through the scenario again where the dog is detecting narcotics.
Well, they didn't specifically mention it. I suspect this is a bomb dog handler.
Oh, okay.
However, basically, let's say it's a checkpoint coming into a parking garage, and the casino or the private security wants to conduct a EDD sweep of that vehicle, and the driver says, nope, I don't want you to do it. I'm not giving you permission to do a free air sniff.
Well, then I would tell them that you have to leave the facility.
Excellent. And essentially, if they don't leave, we can follow up with trespassing.
Yeah, I mean, again, you guys, private security gets to set the rules. Private facilities get to set the rules for security on their facilities. And just like when you go into almost every sports arena now, I think it's printed right on the tickets, even some of them that, or it's posted that, you will be subject to the explosive detection dog works this area or something, whatever. They're put on notice. And so if they're uncomfortable, they don't have to enter, but they don't have the right to go, well, I still want to enter. I'm just not going to go through the procedure. No, it's a condition of you entering. Either you do it or you don't do it.
And it's fair to give them an opportunity to leave. If
right.
That
Yeah.
is
I mean, they
situation.
don't have to, you're not telling them, no, we're going to do it, whether you stay or you leave, we're going to follow you and still do it. No, you're just telling them as a condition of entering this facility and for the security of this facility, you have to submit to this procedure. You don't have to do it, but you don't have to enter the facility.
Excellent. And would that still hold true if we flip this to, let's say, an apartment building with a narcotics dog? Same would apply?
It gets a little trickier with apartment buildings because now you're dealing with a residence.
With a higher expectation of privacy?
Yeah, higher expectation of privacy. In fact, in the 7th Circuit, which is Illinois, Indiana, and Wisconsin, their court has said that law enforcement cannot conduct a warrantless sniff of an apartment hallway. That's a violation of the 4th Amendment right of the residents. So the general rule regarding canine sniffs by law enforcement, if it's open to the public, it's open to you. A Walmart parking lot, I don't know, even the common areas of a storage a secured storage facility. But as far as private, yeah, I mean, let's take that example. I mean, you take a storage facility, right? Both law enforcement and obviously private security have the right to conduct sweeps for detection of contraband. And if it's a good facility, they'll put that right in the lease document to put them on notice that this is routinely done. Most people should be happy to see that if they're not involved in that kind of activity. The guys who are involved in it, well, they're on notice, so if they get caught, they get caught. But an apartment building is a little bit different because you're dealing with higher expectation of privacy, as you pointed out, Ryan. So even at the apartment complex, though, if that's made plain to the residents as a condition of leasing there, then they can either submit or not lease there.
Excellent. Thank you for clarifying.
Yeah.
All right, I've got two additional questions here. One's a little bit longer, but it's from a volunteer search and rescue canine handler. So she's given a situation where there's a wooded sector. She's been called out to search for an elderly dementia patient. Law enforcement is accompanying her. However, the law enforcement officers are refusing to go into the woods for whatever reason. Either they don't want to get dirty, they don't want to mess up their uniforms, whatever the issue may be, and then won't allow her as a volunteer SAR handler to properly search that area. She's obviously a volunteer, but can the volunteer organization be liable for the possible death of that subject because law enforcement ordered them out of that area?
No, because it's not their duty to go and search for that person. They're voluntary. But here's what can happen under the civil law. And the law of negligence says it's based on the concept of duty. So the relationships of the parties give rise to some legal duty on the part of one party to act in a certain way. That's the basic core of negligence.
Excellent.
You might be in a situation like that where legally you have no duty to go in search of this person. But if you undertake the duty, then you have a duty to do it reasonably or properly. So if she breaks off the search and doesn't complete it, does that mean she could be liable because she didn't follow through or didn't find the person? I still don't think so. I think it's purely voluntary. It would probably fall under what we call the Good Samaritan laws, and they relieve people in that situation of liability because they're just doing it to try to help, and they're not going to hold them to that high of a standard. So I think she'd be fine.
Excellent.
Yeah.
Okay, I've got one other question. Great question from Mallory Deschant. It says, in regards to best training records practices from a legal standpoint, and specifically case law or court cases, how important is it for the handler to train with blind, i.e. unknown location of the target, as dogs can be unintentionally influenced by their handler's body behavior and other cues? As a follow-up, are there legal implications for not documenting and training regularly to blank searches?
You know, that's a great question. I really appreciate that question because everything we train to typically involves a positive outcome, meaning there's a find or there's a bite or a person is located. It's not always going to be the case. I think it is important to train to the negative outcome where it's, there's not necessarily going to be an object or a person, and therefore there isn't going to be a recovery or a seizure. I do think it's important. Is it required under the law? No. In fact, there's a lot of narcotics law about whether double blind testing or single blind testing is required to make the narcotics detection team qualified. Most courts do not require any kind of double blind testing. This is probably a good jumping off point for this. The courts really don't require anything. They don't know anything. So they're kind of like going to school. When you come into their courtroom, it's like school's in session for them. They're trying to learn. So they're going to listen to the testimony of industry experts. And there are many, many cases out there on this issue about double blind and single blind testing, where the experts battle it out. And some say, no, it's not necessary, and it's not the only indication of the reliability of the dog. And there are others who say, no, you absolutely need to do it that way. Otherwise, you're risking false outcomes and false positives, etc. So I would say there is, and I don't know if this was exactly her question, but there's no known requirement that I'm aware of for double blind testing. I would say courts are comfortable with single blind testing, but they'll accept even less than that. And I don't think most agencies do. So they're getting certified, and the courts are accepting the outcome.
Copy. So if I'm tracking properly, it's not necessarily a case law requirement, although those of us in the industry would classify that as a best practice.
Yeah, I think, look, anytime you can train more diligently, you're going to show up better and your credibility is going to be higher. It's just how it works, right? So if you got a dog that is accurate 50% of the time in detection, or a dog that's accurate 90% of the time, what dog are you going to be more convinced by? The one that's 90% of the time, right? So.
Gotcha. Agreed. Excellent. At least I'm going to put it out. This is kind of last chance. If anyone else has any questions, if you can go ahead and type it in the chat, we'll ask John. But it looks like let me just double check. Looks like we've hit all of them that were in the chat.
Let me interject this before I forget. Mallory, if you're out there still, if you drop me an email, I will send you, I had to write a memo on that issue of double blind and single blind testing. And it's got some case law in there. I'm not quite sure what agency you're with, but it doesn't matter. I'll be glad to email it out to you. So.
Excellent. Well, thank you. It looks like we don't have, oh wait, no, one last minute question. You got it just under the wire. Not sure on the validity of the statement, but is the NORT, or the National Odor Recognition Test, used by the ATF the only test recognized by the U.S. Supreme Court? I think you've pretty much answered that, but I'll let you go ahead and touch on that.
No, it's not. You'd be surprised at what the courts will recognize. But again, they look behind, like the NORT test, they rely on the NORT test because they understand the credibility of the training that goes into it. But you can come in with a test of any nature, or a certification rather. What they want to do is look behind that certification and know what you had to do to arrive at it. I mean, is this something where you sent in some training records and you got a certificate by mail in a week? Or is this something where you went to a facility that had qualified trainers, you and your dog were there for a period of weeks, you were tested under a variety of circumstances, there were well-kept records. The more credible the training, the more credible the certification, basically. So NORT isn't the only one that would be accepted, no.
And kind of what you touched on earlier of just quality versus the size of the organization or membership base. It's really the quality, whether it's a smaller organization or larger. Is that correct?
There's no question about it. I mean, I've seen it myself. I've seen some very large organizations that have very poor training standards. And you ask yourself kind of like, well, why? Well, they want to brag about how many members they have. So they lower the bar to the point that they can basically retain anybody. And then they just talk about, well, we've got this many members. And I always ask canine handlers, I said, wouldn't you rather be a member of an organization that only had 25 members, but you were like the Navy SEALs of canine, like you were recognized. So it's all about the training and certification standards that are involved, not the name of the organization. So, but I got to be careful here. It's not that I'm not telling you that, ignore national organizations. There are some that have excellent standards and certification. So it's just about that parameter. What is the training? and what are the certification standards. So
excellent. That makes perfect sense. Well, I think we're out of questions. If you guys do want to get in contact with John, especially if you'd love to bring him out to your location to do a full canine case law class for you, wherever you may be, he can be contacted at caninelawyer@gmail.com. And of course, the flyer that was with the email with the link also has a phone number for him. If there's anything else that you'd like to plug or anything else we can do for you, John, go right ahead.
no, look, just stay safe out there, all of you, whether you're in private, public, or even voluntary SAR. Be safe, be true to your mission, hug your dogs, and any questions, reach out.
Excellent. Once again, thank you to Protective Force International, AWPDA, and of course, John Peters. Thank you so much for taking the time and sharing your amazing expertise with our members. Truly appreciated.
Thanks to all of you.
You have a good night, and we'll see you at the next conference.
You got it.
Thank you, John.
Thanks.